Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of our show. Today, we are talking with David Soffer. David, welcome to the show.
Thank you, Matias.
The company the firm, I should say, is Soffer Law Group. And David practices in the area of estate planning and trust administration. And what we are going to talk about today is trust administration. So without further ado, because the audience loves for us to get right in the meat of it, let me ask you questions about how to integrate trust administration in the estate planning process. And I'll explain kind of what I mean. When you do an estate plan, do you tell people, hey, call me when you die? Which obviously doesn't make any sense, because if they're dead, they wouldn't call you. But do you say, how do you explain to them that trust administration is part of the process and it's a service that you offer?
Yeah, of course. So I tell clients and people who talk to us about our business constantly, we do two things. It's all in the vein of trusts and estates, but those two things are interrelated. They are two sides of the same coin. They're estate planning, meaning writing wills and trusts, everything from the straightforward to the complex, and then what's called administration, settling estates and trusts when somebody's passed away. And we represent fiduciaries, meaning trustees, executors, family members, friends who are helping with that estate plan and everything from the straightforward to the complex. So to answer your original question, how do we integrate estate planning and trust administration together? Really, they are intertwined, inextricably intertwined, because the estate plan is the blueprint. The administration is the putting it into practice.
Oh, very nice.
Right? The estate plan is drafted in a way that is, in some ways, hypothetical. There's no way when we're doing the estate plan that we're going to know all the facts of when it comes to be. We won't know when it is, what the laws look like, what the assets are, who's alive, who's not, etc. Now we have to imprint those facts once we've had the actual death. And so we are taking this estate plan that has some holes and has some unknowns and has some, ideally, some flexibility. And now we get to make choices, and we get to do things in the most strategic and efficient and commonsensical way of administering.
That makes sense. Good. Thank you for sharing that. Now, another question came to my mind, so I'm just going to ask it to you. What if you don't do the estate plan? What if somebody says, you know what, I did my estate plan 50 years ago, whatever. My dad did the estate plan so long ago. Do you also help clients do trust administration when you are not part of the estate planning process?
We absolutely do. I would argue that just based on our relative youth, maybe, and the amount of estates that we have seen over the years, we probably have administered more estates and trusts that we didn't write than ones that we did. Those come with, every one of these comes with their own wrinkle. Every one of these comes, and sometimes you know them up front and sometimes you don't. And that wrinkle isn't always the drafting documents, but sometimes it is. And so frequently I find our firm does work with trying to elegantly settle messed up estates and trusts. So there is a common occurrence of somebody, maybe a client, maybe not, saying, hey, the drafting attorney is retired, moved, gone, dead, can't reach him, or didn't have a rapport with him, or what have you. Can you help us with this trust? And the answer is always yes.
Got it. That makes sense. Okay, let me ask you another question now. Because you've seen estate plans that were not perfect, you've seen the wrinkles as you've talked about, has that informed the way you do your estate planning?
Very much. I actually think that being experienced in administration helps inform estate planning attorneys. I think seeing it in practice gives you a concept of what's necessary to go into the estate plan or what's advantageous to go into the estate plan. Absolutely. I would say that there are things that you see in administration that make you say, oh, I better revisit my trusts. I better revisit my forms.
Right. Yeah. Good. That makes total sense. Yeah, absolutely. Let me ask you another question now. There are, people do estate planning in all sorts of ways, and some attorneys don't provide trust administration, or even if they did, like you said, they could be gone. So somebody may try to do it, the trust administration themselves. My question to you is, what are some of the pitfalls that you have seen people who are doing trust administration on their own?
Great question. Great question. Let me answer that with some examples. I have two right now on my desk, one that's gone well and one that's gone poorly. The one that's gone poorly is the one I'll start with. A woman's mother died about 6 years ago. The trust was relatively simple. It said 50% to her and 50% split between her two nephews. This was not our client. She went about it without an attorney. She just said, okay, let's split it up. Very easy. I think there was about $1 million of assets, liquid, and she distributed the accounts. And now 6 years later, she gets a letter from an attorney representing the nephews saying, hey, you didn't give us notice. You didn't give us an accounting. We need all these things. And these are really simple steps that we could have handled at the beginning, but now she's overwrought with anxiety about how do I recreate these things 6 years later?
Right.
So I would say some simple help and guidance at the time would have made all the difference in that one. The other one that I will consider is a plan that we did not write. It was a couple, relatively high net worth. The first spouse died several years ago, and it appears that nothing was done at the time, no administration whatsoever. And now that the second spouse has died and the child is taken over as trustee, she's come to us and said, I think we're going to have a big estate tax due. And we said, well, let us look at this for a minute. What if we go back and recreate what was supposed to be done a number of years ago? I actually think we can lower to the point of eliminating any estate tax due. So if we go back and we recreate what's happened back then, do the things you were supposed to do back then, now we can get to ourselves to a place where we've saved a potential multi-million-dollar tax.
That's awesome. That's great.
Yeah.
It's good to hear this story where there's a solution, there's something that you can do. I want to share a story with my audience related to the fact of doing nothing. Like, the example of, people don't realize that, there are steps that need to be taken when somebody passes away. And I have seen in my career in selling real estate, I've had creditors reach out to me to file probate. So they are not the family, they have nothing to do, but they initiate the probate process because the family did nothing. So they're creditor to the deceased. The deceased dies. Nobody does anything. The deceased is an asset, a real asset in the case they reach out to me. And a creditor can initiate the probate. Now, that's scary because people, families, you got to do something about it. You got to find out, when somebody passes away, take action, which leads us into the trust administration process. We had another opportunity to talk about probate administration. Do you do that as well?
We do. We absolutely do. And as you point out, there are a lot of laws and a lot of potential pitfalls there if somebody doesn't necessarily address the issues. And I don't mean to turn this on you, but have you seen the situation where mom and dad own a property in joint tenancy? And one of them dies and the other says, it's mine. I don't need to do anything. And when they die, got a real problem and a real mess.
Yes, all the time. I mean, you'd be surprised. That's why, we have to be proactive, just as you are in your practice. When a property is brought to us, we look at the preliminary title report, we do the chain of title. If there's no filings at all about a death and all of that, those things need to be fixed, because people will understand this, like a title company insures title, but only if they can prove that the person that's selling has authority to transfer the title. If the person whose name is on the title is dead, that's an issue right there. So,
That's correct. That is a probate issue.
yeah, exactly. Let's talk about how managing a trust. I mean, you already gave me an example. I think you gave me a great example, but let's go a little bit into more depth of, how effective trust administration made a significant difference for one of your clients.
Sure, of course. And I think that example that I brought up earlier about going back and recreating is actually not terribly uncommon. There is frequently, and oftentimes we will counsel the client of, does this make sense to do, or does this not? I mean, to use your word, practicality is what drives us. And so if it does not make sense and there are no downsides or detriments to ignoring it, sometimes we do it that way as well.
Right.
But to address the question of effective trust administration benefiting clients, I would hope, and I think that the attorneys that effectively can help administer the trust pay for themselves and more.
Right.
They're between the simple hand-holding when it comes to tax implications and dealing with beneficiaries. Litigation's expensive.
Right.
And so dealing with beneficiaries that may or may not be upset with the way you do things, and some simple and direct communication, that could be all the difference in the world. So some of those, knowing that you're going to hit the right spots, knowing when to choose what to say, what not to say, I think ideally those are the guides that an effective attorney can provide a client and keep them out of trouble and get things settled in an effective way.
That makes perfect sense. Thank you for sharing that with us. Let me ask you another question that is, it's a practical question.
Yeah.
When somebody passes away and they reach out to, the trustor, the settler of the trust passes. Now the trust becomes irrevocable, right? Basically, that's the standard. I think, right? Am I okay? And they reach out to you. What are the steps? They say, they know maybe you also did the estate plan. They say, David, this has happened. What do we do now?
What do we do? And as I mentioned, every one of them is different. Every plan is different. It's not necessarily cookie cutter, but there are certain things that we know we need to do.
Right.
So to begin with, we know we need to notify all the people who are required to get notice. And I mean all the people who are named in the trust, and I mean all the potential heirs of the trustor, meaning the people who would take or inherit if there wasn't a plan.
Right.
We also know we need to, one of the biggest things that we need to do is get our hands around what assets exist, what are out there, and get this person on what's called title, right? Get them empowered to act on behalf of these assets. That's going to be critical. So that we have, and the sooner the better, so that we don't have any lapse in time of paying bills or nobody caretaking any of the assets, both real property and liquidity. If there is going to be an estate tax return, because we're at a place where we're over the exemption, that's in fact, in some ways, a roadmap for the administration, because that document is going to require us to divulge a lot of the things that are going to happen along the way of the administration. We have to have the assets appraised and turn them over to the IRS. And so all of those things probably need to happen at the beginning. Where it goes from there can depend on the assets, the institution, the desires of the trustee and the beneficiaries, and so on and so forth.
Yeah, that makes sense. Now, you mentioned something about, high value estates, and that's another question that I wanted to ask you. Everybody, we have our primary residence, et cetera, but there are some unique assets. People can own, a Dairy Queen in Omaha, whatever. So my question is, when you're doing the inventory, et cetera, how do you deal with assets that, are not the typical cookie cutter common assets that people have in an estate?
Great question. Important question, because I think that one is going to require a specialized appraiser. That's going to be really key. And to find that specialized appraiser may take some time. And
Right.
so getting on that one early in the process is going to be critical, I think, especially if, as I mentioned earlier, if there's an estate tax due, there's a time limit on that. That's generally 9 or 15 months if you extend it.
Right.
The date of death. And that's going to need a qualified appraisal. So finding that right appraiser and getting them engaged and getting that process rolling early is going to be critical. The other thing I think is wrapping our heads around what this asset's going to take to manage.
Right.
Is it a piece of real property or another type of investment out in a place where we don't have physical location and boots on the ground? Okay, well then what are we going to do about that?
Right.
Is it a limited partnership investment or maybe a general partnership investment? Well, should we talk to the manager? Should we talk to the GP or should we figure out what we're going to do there? What's required? So some of those steps I think are really critical early on for unique assets.
So when you're in the world of estate planning and trust administration, you have to become, I don't want to use the word expert, but you have to be prepared to deal with things. I've talked to people that have had states where they own company outside the country, or like art collections that were like, located somewhere else. I mean, you kind of have to learn, because that's not something that happens to you every day. Somebody's not going to say, yes, I own a collection of statues in Italy that is, it's so you have to kind of, you as their point of contact, obviously, will help them sort of like figure out how to handle these things. Is that correct?
Not only is that correct, it's part of what I love about what I do. In some ways, it's exceedingly niche. We do trust and estates, and that's what we do. But trust and estates, as we can already agree, comes with everything, just about. It definitely comes with tax and real estate and intellectual property. There are some family law aspects to it. There's you name it, and we've got it. So in some ways, you just got to use a little bit of common sense and problem solving in this field as well. If it's statues in Italy, I love them, but I don't know the first thing about valuing them. So we're going to have to figure out and put our heads together. What are we going to do about this?
Right. Yeah, that makes total sense. Now, I'm not a proponent, or when it comes to these things, I always like to say this. If my audience is going to get tired of me hearing this, but I just keep saying it anyway, because I love the sound of my voice. I say, if the person the attorney who represents themselves in court has a fool for a client. Okay, you know that expression. Okay, great. So whenever people say, "Oh, I'm going to try to sell my own house," I always say, like, "Oh boy," those are also the most difficult client, by the way, when they do stop, when they realize that it's too complicated to do it. But even though I'm not a proponent of DIY when it comes to these things, because there's usually a lot of money involved, et cetera, if somebody were to decide, look, I'm going to do my own trust administration, what is one advice that you can say, look, don't make this mistake at least?
Yeah. Well, and I think this is trust and probate.
Right.
I would say the answer is notice is a big one, right? Make sure that everybody that is entitled and required to get notice gets notice, because that seems to be, especially with the backstop, even in trust, the backstop is a probate court can always be applied to weigh in on what's going on.
Right.
Probate courts, one of their biggest things is, did the people who need to get notice about what's happening get notice so that they know that they can have their time in court?
Yeah.
Just speaking to the concept of this DIY, it can be done. I've seen it done. But I would also say, I think I would remind somebody, the estate or the trust is going to pay for the attorney. And if you choose wisely, the attorney is going to pay for themselves and more.
Right.
Especially given that the probate court, specifically in probate, the probate court gives a lot of leeway to somebody who's doing it themselves, what we call pro per, representing themselves, but not infinite. And it's going to be pretty hard to navigate and get things right and get things moving. And what is your time worth and what is your effort worth? And truly, especially in probate, where it's what's called a statutory fee, meaning the law says what the attorney gets paid, you can choose whichever attorney you want and pay the same price. So might as well get a good one.
Yeah, that makes sense. Very good. Great point. Let's talk about your journey. This is the fascinating part that I love. My audience loves to connect. And I guess my first question is, Did you want to be an attorney when you were a kid?
No, no, I did not. No, I did not. I will be perfectly upfront with you. I loved college, enjoyed it, but
Okay.
when college was nearing to an end, I said, I want some more school, and looked around and said, my friends are going to law school. That sounds good to me. Let's go. So I went and thinking it'll open doors, and in some ways
Uh-huh.
it does, and it did. But no, it was not my plan at 18 years old by any stretch.
Got it. Now, when you were in law school, this is another big question. Obviously you took your trust and wills class.
Mhm.
Where did you know that that was the area of law you were going to focus on?
No, not at all.
Okay.
In fact, I didn't to begin with. My
Mhm.
career started at one of the biggest firms where I was in civil litigation, and it took me a
Okay.
couple of years to realize I didn't really care for it.
Okay.
Switched to a different big firm where I was in the corporate department doing like M&A and securities.
Mhm.
But that is where I got some exposure for the first time to trust and estates in the practice of law,
Okay.
because we did a deal with the Frank Sinatra estate. We
Oh,
did
wow.
Yeah, we did. I had some work with one of the T&E attorneys there on some nonprofit work. And that
Mhm.
was also the first time that I was brought in by my in-laws when they were updating their estate plan. So all of these things kind of at the same time, it was almost like when I decided I don't think big firm life is for me. I enjoy my autonomy too much. That was when a light bulb went off and said, this is, you know what, now here's a practice area that I can do. And I could potentially do this on my own. And I can have individuals as clients, not giant corporations. And I've always had a mathematical bent. So the
Mhm.
tax side of what we do made a lot of sense for me. So all those things kind of finally funneled me into where I am now.
Okay, so the way I like to say it here is that your area of practice found you. You did
Oh,
not look
absolutely.
for it. You
Absolutely.
leaned toward it when the opportunity presented itself. Because you went from big law to your own firm. I want to kind of discuss the change. I mean, when you're in big law, the business it's funneled from in most of the times from the exposure that the firm has, from the cases they have, et cetera, et cetera. You don't necessarily get to pick. You work with, depending obviously on where you are on the ladder. Was it scary to say, okay, I am here with this big firm, and now it's just going to be me. I'm going to be the hunter that is going to search for the business.
It's a great question. It is. And I'm sure looking back, certainly there was some times where you are having to take a leap of faith, and
Mhm.
that can be scary. Absolutely. This was this was 3 kids ago, 3 mortgages ago. My wife was working. I mean, it was a different stage of life as well. And it was a good opportunity. If I was going to take a risk, that was the time. And I actually did not go straight. I took a year, or actually even less, to go back to law school and get what's called an LLM in tax, because a
Oh,
lot of what
okay.
I was planning with the idea of opening my own shop. And in fact, during that first year is when I took some of my first clients.
Got it.
And so that was a nice transition for me. And I ended up joining a solo attorney in his office. So there was some infrastructure built in to begin with. But you're right. I hung a shingle and said, let's see what happens. I grew up in Los Angeles. I have professional and personal contacts, but who knows? Who
Right.
knows? Let's see what happens. Let's see what comes.
That's awesome. I like to say that this phrase is a little bit overused, but the fortune favors the brave.
Yeah,
You were
right.
brave. You took
That's
a
right.
chance. You took a
That's right. In
chance.
hindsight, I feel much braver than I was at the time. It felt like a common sense thing to do at the time.
Yeah, yeah. It's funny because my parents always say, "My God, I can't believe you moved to Los Angeles from Italy by yourself at 18. You're so brave." And every time they tell me, I honestly think like it made total sense to me. Why not go across the world and search for fame and fortune rather than
That's right.
stay?
That's right.
But anyway, it's been such a pleasure to talk to you. Thank you so much for coming on the show.
Oh,
Before I let you go,
pleasure's been mine. Thank you.
thank you. Yeah, before I let you go, David, can we're gonna have your contact information, your firm information in the show notes. But what is the best way to get a hold of you? If you could share, what the best way for those who are just listening to the podcast.
Absolutely. Email is always great. You can
Okay,
email my email at david@sofferlawgroup.com, or even info@sofferlawgroup.com. They'll both get to
perfect.
me. Or you can call our firm, 310-284-7306.
Perfect. Wonderful. Thank you so much. It's been such a pleasure to have you on the show. Thank you, everybody who have joined us. And if we don't hear from you sooner, we will see you in the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020544763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.